Good afternoon. This short video is for GPs about the GDPR. The General Data Protection Regulation, or GDPR as it is commonly referred to, comes into effect in the UK on the 25th of May 2018, and as of this date it is applicable by law. The implementation date has been set, but fear not, this does not mean you have to have unfaltering systems in place. So the GDPR journey has already begun, the effective date is fast approaching. However, if you have the appropriate systems in place to show you are working towards compliance, you are showing a proactive approach. Whilst there is a lot of hype surrounding the subject, it is worth noting that the key principles of the Data Protection Act have in essence been strengthened by the GDPR. There's also a new Data Protection Act which will be called DPA 18, replacing the existing DPA 98. But what does all of this mean to you as a GP? Okay, let's begin with your practice. When the GDPR comes into effect, your practice, unless you decide to nominate an individual, will become a data controller. And as a controller, the practice has a duty to ensure that personal data is processed in accordance with Article 5 of the regulation and should be able to demonstrate compliance with the regulation. Furthermore, the data controller has a responsibility to ensure data processors comply with your internal policy and the GDPR. Now, there's also been much discussion about data protection officers and who is suitable to undertake this role. For the larger practices, it may be decided that they will appoint their own data protection officer, or a group of practices may opt to share a data protection officer. Smaller practices may also share a data protection officer who has been provided by the CCG or Federation, but this is something which will be decided within your region. Practice managers or one of their colleagues can undertake the role of a data protection officer, but let us not forget the amount of work they already do. But to be suitable to undertake the role, the individual must have some data protection experience. Further guidance is available and has been published by the IGA. Now, although the subject of GDPR has been widely publicised, do your patients know how the GDPR affects them, what their rights are, the changes to accessing their data? So one way you can ensure they do is to update your practice privacy notice. And as you already know, a practice privacy notice is a statement that disclosed some or all of the ways in which your practice gathers, uses, discloses and manages patient data. It fulfills a legal requirement to protect a patient's privacy. To be GDPR compliant, your practice privacy notice will need to be concise, transparent, intelligible, easily accessible, written in clear and plain language, particularly if it is addressed to a child, and lastly, provided free of charge. More specifically, it will need to explain what information is collected, how that information is used, how confidentiality is maintained and how patients can access their records, risk stratification, invoice validation, opt-outs, retention periods, what patients should do if they have any questions, how a patient can complain and to whom they complain, and when changes to the privacy policy will be published. So now your patients know how to manage their data and how they can access it. You need to know what has changed for you. Well, response times have changed. You must now comply and respond to subject access requests within 1 calendar month. Additionally, you're no longer permitted to charge a patient for a subject access request. Now, we all know that third parties, such as insurance companies and solicitors, should request copies of notes using the Access to Health Records Act and not a SAR. However, the BMA have advised that when requests for copies of records are received, even from authorised third parties, you are not permitted to charge a fee. But the BMA are in the process of updating their guidance on this subject, which will be published in due course. So what else do you need to do? You need to understand how data flows throughout your practice. The best way to do this is to undertake a data mapping exercise. Take a look at the GDPR policy I've written for more information on this subject. Implement and embed the policy in your practice to ensure compliance. Ensure your team understand the GDPR and their responsibilities as data processors. You all need to understand what constitutes as a data breach, which is any incident that has affected the confidentiality, integrity or availability of personal data such as unauthorized access, loss of data, loss of IT equipment or personal data being sent to the incorrect recipient. And you also need to know what breaches need to be reported to the Information Commissioner's Office, or the ICO. And when a breach merits reporting, it should be reported without undue delay or within 72 hours of being identified using the Data Protection Breach Notification Form. Failure to do so can result in a fine of up to €10 million. Getting further guidance for this subject can be found on the ICO website. You will need to understand the need for consent and the differences between explicit and implied consent. So under the GDPR, there is a lawful basis for processing healthcare data if it is for the provision of direct care. This doesn't require explicit consent, so implied consent is applicable where the processing is necessary in the exercise for the official authority vested in the controller. A good example to give of implied consent is when a patient agrees to a referral to a specialist from the GP. They are agreeing to their healthcare data being shared. Explicit consent is required if it is not for the provision of direct care, such as requests by a third party for patient information. The patient must give their explicit consent to share their information if the processing of their healthcare data is to be lawful. And just remember, it is you as the GP who must be confident that there is a clear legal basis for the disclosure of personal data, and if any doubt exists, then further guidance should be sought. Your patients can object to the data being processed unless there are compelling legitimate grounds for processing, such as the safe provision of direct care or when processing is necessary for legal purposes. Another introduction is the right to erasure or the right to be forgotten. In healthcare, it is unlikely that this right would apply save for instances of unlawful processing of personal data. If requests for data to be amended are received, the original record must be retained for audit purposes. Now that's a lot to take in and apply in practice, but remember that to make your practice GDPR compliant, all of the team need to be involved. It is not a one-person process. To support you, take a look at the available resources on this site. There is a GDPR policy, an e-learning package, a GDPR blog, GDPR videos, and a GDPR quiz, all aimed at providing you with the necessary information to make your practice GDPR compliant.